On August 8, 2019, 2 days before his death in federal custody, Jeffrey Epstein signed a 32-page document known as the 1953 Trust. It allocated roughly $100 million to his closest associate, $50 million to his personal lawyer, $25 million to his accountant, and $10 million to his brother. His estate was valued at between $577 and $600 million. He was a convicted sex offender awaiting trial on federal trafficking charges, and yet the architecture around him, legal, financial, contractual, had held for decades. The question isn't who Jeffrey Epstein was. The question is what kept him protected. The answer isn't a person, it's a system, a legal architecture of non-disclosure agreements, settlement clauses, and institutional complicity that converted abuse into a recurring cost of doing business. And that same architecture, built from the same contractual tools, was running simultaneously inside Hollywood. A non-disclosure agreement is, at its most basic, a contract that exchanges money for silence. One party pays, the other agrees not to speak, not to the press, not to other potential claimants, sometimes not even to a therapist. Breach the agreement and financial penalties follow. That's the standard version. What Epstein and, in parallel, Harvey Weinstein used were something more precisely engineered. The first mechanism is the liquidated damages clause. Rather than leaving the financial penalty for breach to a court's discretion, liquidated damages preset the penalty in the contract itself. For a victim with limited resources, that preset figure, often far exceeding the original settlement payment, functions less as a legal provision and more as a threat. Speaking becomes economically catastrophic before it begins. The second is mandatory arbitration, combined with forum selection clauses. By routing any dispute into private arbitration rather than open court, these clauses ensure no public record is created, no filing, no docket, no discoverable pattern. Each settlement remains isolated, invisible to the next victim and to any future plaintiff's attorney. The third is mutual non-disparagement. On its surface, this appears balanced. In practice, it operates asymmetrically. The institution retains its reputation. The victim retains nothing except the obligation of silence. Taken together in the context of serial abuse settlements, these form what one employment lawyer, quoted in the New York Times following the Weinstein revelations, described as a system that allowed him to silence complaining victims and just see it as a cost of doing business. To understand the scale of what Epstein built, start with the money. At the time of his death, his estate was valued at between $577 and $600 million. The 1953 Trust, signed in federal custody, allocated assets not randomly but strategically to his lawyer, his accountant, his brother, and his closest associate. According to estate filings and reporting by the Miami Herald and the New York Times, the Trust's beneficiaries were the people closest to the operational core of his world. That financial architecture didn't appear overnight. It was the final layer of a system assembled over more than a decade. The foundation was the 2007 non-prosecution agreement. Federal prosecutors in the Southern District of Florida, under U.S. Attorney Alexander Acosta, negotiated a sealed deal that granted immunity not only to Epstein, but to unnamed co-conspirators. The agreement was concealed from victims in violation of the Crime Victims' Rights Act, a conclusion confirmed by the Department of Justice's own 2020 internal review. A federal investigation into sex trafficking of minors was converted, through negotiation, into a state-level prostitution plea. Epstein served 13 months, largely on work release. The federal exposure disappeared. Epstein's defense team included Roy Black, Alan Dershowitz, and Ken Starr. According to reporting by the Miami Herald and subsequent court filings, the team used procedural challenges, sealed filings, and escalation to the Department of Justice's Criminal Division to narrow the case at every stage. The strategy wasn't to contest the evidence, it was to contain the forum. The civil settlement layer operated in parallel. Court records and reporting from the Miami Herald's 2018 investigation document at least 8 civil settlements with NDAs executed before Epstein's 2019 federal arrest. Among the most consequential was the 2009 settlement with Virginia Giuffre. That agreement included broad waiver language purporting to release claims against unnamed third parties, language later ruled ineffective in litigation involving Prince Andrew, where a federal judge found the clause too vague to bar Giuffre's claims. The clause had been drafted to reach far. The court found it didn't reach far enough. What made these settlements particularly restrictive, according to court filings and legal analysis cited in subsequent civil litigation, was the combination of clauses operating simultaneously. Victims were prohibited from speaking to one another. In some documented cases, confidentiality obligations extended to therapy. The settlement's financial relief came attached to conditions that constrained the victim's ability to process what had happened. For a victim receiving a settlement in the low six figures, a preset damages clause in the millions functions as a permanent deterrent. The contract doesn't need to be enforced. It needs only to exist. The institutional layer extended further still. Deutsche Bank and JP Morgan Chase later paid a combined $365 million to resolve claims that they processed transactions for Epstein while ignoring documented red flags. Those settlements, reached in 2023, confirmed what civil complaints had alleged for years, that the financial infrastructure around Epstein was not passive. Banks, law firms, and advisors processed the money that funded the settlements, the travel, and the operational costs of an enterprise that continued for years after his 2008 conviction. The silence machine wasn't Epstein alone. It was a set of institutional relationships, legal, financial, contractual, that each performed their individual functions, while collectively ensuring the pattern held. At the same moment, an almost identical machine was running inside Hollywood. Harvey Weinstein reached at least 8 documented non-disclosure agreement settlements before the New York Times published its investigation in October 2017. The first occurred in 1990, according to reporting by Ronan Farrow in The New Yorker and subsequent civil litigation. That means the pattern began forming at roughly the same moment Epstein's did, and it ran, largely uninterrupted, for nearly 3 decades. The most thoroughly documented early settlement involves Zelda Perkins, a former Miramax assistant. In 1998, Perkins and a colleague received a combined settlement of approximately $425,000 after alleging sexual misconduct by Weinstein at the Venice Film Festival. The NDA they signed, which Perkins later described in testimony to the UK Parliament and in public statements, prohibited the two women from speaking to each other about what had happened. It barred them from retaining copies of the agreement itself. It required that any therapy sessions be covered under the settlement's terms, but that Weinstein not be discussed during treatment. If a therapist needed to be informed, that therapist was required to sign a separate NDA. The institutional layer around Weinstein operated on the same logic. According to the New York Attorney General's 2018 lawsuit against the Weinstein Company, which alleged that executives enabled misconduct through non-disclosure agreement settlements without corrective action. 16 former and current executives and assistants confirmed awareness of Weinstein's conduct. The board received repeated complaints from the 1990s onward. The documented response, across decades, was not investigation or termination. It was settlement. Each complaint became a transaction. Each transaction came with a clause. The Attorney General's lawsuit framed this not as individual moral failure, but as institutional practice, a legal and operational structure that processed misconduct as a cost of doing business rather than a condition requiring correction. Weinstein extended the machine beyond contract. According to Ronan Farrow's 2017 reporting in The New Yorker, Weinstein retained the private intelligence firms Black Cube and Kroll to surveil accusers and journalists investigating him. Black Cube operatives, working under false identities, made contact with accusers to gather information that could be used to discredit them. This was the silence machine operating outside the contract, using active intelligence methods to reinforce what the NDA clauses had already put in place. The contract created the legal risk. The surveillance created the personal risk. Together, they closed the space available to anyone considering disclosure. The entertainment industry's relationship with institutional silence predates both Weinstein and Epstein. The studio system of the 1930s and 1940s managed scandal through morality clauses, loan-out contracts, and coordinated gossip column management. The non-disclosure agreement, as deployed by Weinstein's legal team, is the modernized version of that function. The mechanism changed. The institutional purpose, protecting the enterprise from the conduct of its most powerful figures, did not. The Weinstein Company's 2018 bankruptcy ultimately terminated all existing agreements as part of the proceedings. When the legal architecture collapsed, the silence it had maintained for nearly 30 years collapsed with it. But the board only moved to remove Weinstein in October 2017. Not because the system failed internally, it failed because journalism broke through it. If you follow this kind of forensic breakdown of power and institutional failure, subscribe to the channel. Now, this is exactly what we do here. The silence machine didn't operate in isolation. It required infrastructure, and that infrastructure had names. Deutsche Bank and JP Morgan Chase processed transactions for Epstein across years when his criminal history was a matter of public record. His 2008 conviction for soliciting prostitution from a minor was not obscure information. It was documented, reported, and available. Both banks later acknowledged, in settlement agreements totaling $365 million reached in 2023, that internal red flags had been identified and not acted upon. JP Morgan's settlement with the U.S. Virgin Islands included findings that the bank had processed payments consistent with sex trafficking recruitment. Deutsche Bank's settlement with the New York Department of Financial Services cited failures in anti-money laundering compliance. These were not passive oversights. They were institutional decisions made repeatedly over years. The same institutional logic operated inside Hollywood. The law firms and talent agencies that processed Weinstein's settlements were not peripheral actors. They were the mechanism. According to the New York Attorney General's 2018 lawsuit against the Weinstein Company, the board had received repeated complaints over decades and responded with NDA settlements rather than corrective action. The AG's filing framed this as institutional complicity, a legal failure, not merely a moral one. The same law firms operating across Hollywood managed similar settlements for other clients. The Weinstein machine was not an anomaly. It was an acceleration of existing industry practice. The keystone holding both systems together was mandatory arbitration. By routing disputes into private arbitration rather than open court, both settlement structures ensured that no public record accumulated. Each settlement was sealed off from every other. The silence wasn't just enforced at the individual level, it was structurally prevented from becoming collective. That is what made the pattern sustainable across decades. Isolation, built into the contract by design. The reform moment came from outside the system. California's legislative reforms moved to restrict non-disclosure agreements in sexual misconduct settlements. The UK Employment Rights Act, which received royal assent in December 2025, voids agreement clauses that prevent disclosure of harassment, a direct legislative response to the patterns documented in cases like Perkins. These reforms confirm by their very necessity what the record had already shown. The architecture was functioning as designed. It required external force to dismantle. What the Epstein and Weinstein cases demonstrate together is that the silence machine was not the product of exceptional criminality. It was a replicable legal product, available to anyone with sufficient capital, the right attorneys, and access to institutional relationships willing to process the transactions. The tools were standard. The application was systematic. The silence machine wasn't unique to Epstein or Weinstein. It was a template, assembled from standard contractual components, available to anyone with enough capital and the right legal team. For entertainment industry systems, that template has a longer history than most acknowledge. The non-disclosure agreement is the modern version of the immorality clause, inverted. Where the studio-era clause protected the institution from the talent, the modern agreement protects the powerful from the people the institution claimed to represent. The architecture held for decades. It took journalism, bankruptcy courts, and legislative reform to begin dismantling it, not the system correcting itself. If you want to understand how entertainment industry contracts have historically protected power at the expense of the people inside them, this case is where that pattern becomes impossible to ignore. Watch this next. And if this kind of forensic breakdown is what you come here for, subscribe. We go deep on the systems behind the stories.